But what usually happens is if somebody is charged with theft, the first thing that happens is when the defendant will be arrested, taken to the police station. There'll be the procedure at the police station, and then it's decided to charge the person with an offence. So the Crown Prosecution Service will decide to charge the person, or say to the police, go ahead and charge. The offence is paid for by the state. Often they will have to make a contribution nowadays, so sometimes the contribution can be quite hefty. So they'll be given a date to go. No, they might be in custody, but if it's a very minor case, the likelihood is that they'll be on bail. So they'll be bailed to appear at the Crown Court. Nowadays, they don't bail people from the police station so much. They will release them under investigation. A court a few years ago, I think it was in 2011, decided that if a person was re-bailed or was bailed by the police to come back for inquiries, the clock continued to tick. So all the time that they may have spent in custody counted towards the maximum time that they were allowed to be kept by the police. So if they came back, the clock would start again, and if they were re-bailed and then they came back, the clock would continue to tick until the point where the police ran out of time. So to get round that, they decided to go over to what was called releasing under investigation. So you'd simply be released under investigation. You wouldn't need to go through the whole palaver of bail. And then when they asked you to come back, you would come back, and there was no problem with the clock ticking. But once the person is charged, then they have to be bailed, if they're going to be on bail, to a court attendance at a certain date. So they're given a date to attend at the magistrate's court. Unless, of course, it's very serious, in which case they'll be remanded to appear, the police will keep them in custody and will produce them at the magistrate's court at the next hearing. So if they're decided to charge them on a Friday, they'd appear on a Saturday, but if there was no court available on the Saturday, they'd be held and produced on the Monday. Or they'd be bailed, as I say, depending on, and the question whether they get bailed or kept in custody is a matter within the police themselves. A custody officer would decide whether to give them bail pending the appearance at the court in due course, or held in custody for the next court session. They're given a date sometime hence, probably maybe 2-3 weeks hence, a month, to appear on bail in the magistrate's court. So they come to the magistrate's court, they surrender to the court. So when I started at the bar, when a person surrendered to their bail, they actually had to go into the custody area to be supervised by the court jailer. Nowadays that doesn't happen. What happens if you're on bail? You simply wait in the public area, and then when the case is called on, you go into court and you go and sit in the dock, the rail there at the back of the court that holds the prisoner or the defendant. So they'll be called into court, and they'll surrender, and the first thing that happens is they'll be asked to identify themselves. So what's your name? And they will give their name, date of birth, give their date of birth, because you have to be sure that you're talking about, it's not an imposter. But actually, I can't see why it's necessary to ask them to give their date of birth, because it's fairly clear that the person who's there will be known by... Well, I think I know the reason, because the police officers often who arrested them won't be at court, because the police don't supervise. It used to be the case that they'd be brought by the police. Nowadays it's all done by the CPS, so they would have no reason to know whether this defendant was in fact the defendant who'd been arrested and bailed. And then they're always asked nowadays what their nationality is. And it's okay if you are actually sort of white British, but there are so many, particularly amongst the black ethnic community. I mean, only yesterday I was in a case where some chap said he'd hesitated, he didn't quite know what his nationality was. So he said he was, they will say black British rather than British. So they'll say black British, but this chap said black African, because he didn't know what his nationality was. He didn't know he was British. The first thing that happens in a court is the court has to decide whether the case can be tried in the magistrate's court as a summary trial. Summary means there and then, but usually, well, in fact, never do cases get tried there and then when they appear for the first time. It always has to be adjourned to another date. But traditionally, the summary trial means there and then or very soon. So the court has to decide whether the case is one that's suitable for trial in the court, the magistrate's court, or whether it has to be sent to the Crown Court. So the first thing they decide is, when they go through this process of what's called mode of trial, that is where it's to be tried, magistrates or Crown Court, is that what they do is they ask the defendant to give an indication of what their plea is likely to be. So they will say, can you tell us what plea you intend to make in this case? So they will say guilty or not guilty. If it's not guilty, that will be a factor that will determine whether the case can be tried in the magistrate's court. Having got from the defendant an indication of what the plea is, supposing it's a plea, no, not guilty, the court then has to decide whether the case itself is inherently more serious in terms of the likely sentence, if there's a conviction, than the magistrate's court has a power to impose. Now, magistrates' courts normally only have a power to impose a prison sentence of up to 6 months. In some cases it can be 12 months, but normally it's 6 months. So one of the factors is whether the case is so serious that it's going to be the sentence is much longer than the court could conceivably impose. So, for example, although the sentence might be, it's possible that it could be as long as, say, 18 months, it might well be that the case, that it's actually not so serious, that a sentence less than 6 months could be the outcome. So, for example, although on the face of it, the case could be one where it could be as long as, say, 2 years, given all the possible mitigating factors, that is, factors like the fact that the defendant has no previous convictions, that they've got lots of good things that can be said about them, it may be that although on paper the sentence could be as much as 18 months, for example, the likelihood is it could be a lot shorter than 6 months, in which case there's no point sending them to the Crown Court for trial when it could be adequately dealt with in the magistrate's court. So the court then decides, that makes the decision whether it should be tried in the Crown Court because of its gravity, or whether it can be dealt with adequately in the magistrate's court. So the court will make that decision, and sometimes it's a fine balance. And it used to be the case that if the court makes a decision that it can be tried in the magistrate's court because it's really not that serious, so it decides, courts decide that it is suitable for trial in the magistrate's court. We make that decision. However, that's not the end of the story, because the defendant has the final word as to whether it should be tried in the magistrate's court or in the Crown Court. So ultimately, the defendant is then, the final decision then, or final thing that happens, is the defendant says, the court says to the defendant, the court have decided that this case can be tried in the magistrate's court. You can decide whether you want to be tried in it's your decision whether you want to be tried in the magistrate's court or whether you want to be tried by judge and jury. If you decide, the defendant will be told, if you decide to be tried in the magistrate's court, if after hearing all about you and all the circumstances and any past convictions that you might have, the court might decide nonetheless to send you for commit you for sentence to the Crown Court, if it decides that in all the circumstances its powers of punishment are actually inadequate in the particular case. Having heard that, where do you want to be tried? And the defendant will either decide to be tried in the magistrate's court or in the Crown Court. And that's where we come to that peppercorn case where the defendant, charged with the theft of a packet of peppercorns, decided that he wanted to be tried in the
calculation the defendant might make.
Right. The decision will usually be because you might want to delay the ultimate outcome of the case for various reasons, or it may simply, but normally it would be because the defendant will calculate that you stand a better chance of being acquitted by a jury rather than magistrates, because magistrates tend to be, it's commonly supposed, will be case hardened. In other words, they'll suffer from something that's called excuse fatigue. In other words, we've heard it a million times, the same old defence, we don't believe a word of it. So, they're more likely to convict in the magistrate's court. And the statistics bear this out. I haven't looked at the most recent statistics, but I know that years ago, the chances of your being acquitted in the magistrates' court on a trial are substantially, significantly lower than if you're tried by a jury. The usual, years ago when I was interested in looking at the statistics, I think the chances of an acquittal or conviction acquittal were about 50% by jury. Magistrates tend to be much less likely to acquit defendants.
I think I remember in previous years, David, you saying if somebody were black, Asian, they may well go for a jury trial because a jury may represent their ethnicity and interest far more than.
Well, this is correct. This is correct. Yeah.
Well,
I mean, it is up to a point, but magistrates tend to be now. I mean, in areas where there's an ethnic population, significant ethnic population, they are quite well represented by ethnic minorities now. Certainly in areas where there are, high concentrations of.
Even if there's a black or Asian magistrate, they probably will not be of the social strata as your defendant.
Well,
the jury may be.
They might be. I mean, I think that there's very little research being done on this. It can only be assumptions, of course. But I think by and large, you'll find that magistrates, for reasons unconnected with their ethnic makeup, will tend to be case hardened and will tend to convict whatever the ethnicity of the defendant. The decision is made, so the defendant will very often be advised, or will of their own volition decide they would prefer to be tried by a judge and jury because the likelihood of conviction is less. And so they will then will make the decision, and they'll be advised very often, if you want reasonable chance of getting acquitted, then you better go for judge and jury, or it'll be a jury that make the decision. Now, as I say, it used to be the case that if you elected that if the court decided that it was suitable for summary trial, the defendant, if they chose to be tried by a jury, could be, and they were acquitted, they could be made to pay much greater costs than if they were acquitted ultimately than if they were dealt with in a magistrate's court. And so there could be all sorts of financial considerations there. The hope would be that the magistrates in borderline cases would go for deciding that it was too serious to be tried in the magistrates' court. So they would decide that it would be sent for trial, and it wouldn't be the defendant's decision. And there was a time years ago where when they made this mode of trial decision, when the court made the mode of trial decision, they didn't actually ask defendants what their plea was going to be. And that's been a bit of a handicap for defendants now, because you could delay the indication that you gave on what your plea was going to be to a much later date. So if you got to the Crown, in the old days, if you got to the Crown Court and you hadn't given an indication, because in the old days you didn't have to give an indication of what your plea was going to be, and then you decided at the last, the 11th hour, well, actually I'm going to, you'd plead guilty rather than giving an indication, stringing it out essentially. I remember several occasions when the prosecution, in a case that was borderline, would say, no, we say it's suitable for trial in the magistrate's court, because they make a recommendation. And so then the defendant would be, or the defence representative would be asked to if they had any observations on whether they thought it was suitable for summary trial or not. And I remember frequently saying, "Oh, I don't know. It seems pretty serious to me." And if the magistrates plainly, they felt on weak ground, and they were a bit sort of they were looking to the prosecution for guidance and were a bit unhappy with the prosecution's recommendation that it was suitable for trial in the magistrates' court. They were looking for somebody else to give them a kind of steer. So if the defence say, "Oh no, it looks pretty serious to me," "Oh yes, quite so," they will refuse jurisdiction. So you've got exactly what you wanted. You've got the case sent for trial. The defendant wouldn't be in any danger of having their costs, having an order for costs made against them, and the defence solicitor wouldn't be criticised in any way, because it's always possible later on that they might be criticised by the judge for having advised that it ought to be, or having advised their client to elect trial. If the evidence, for example, is very strong, and they've said that nevertheless they want to fight the case. Nowadays we have all the evidence served on us, so we know exactly what the evidence is, or what it's likely to be, because witnesses have made statements. So you see the statements that they've made, you see the way the statements fit together, and therefore how strong the case is or not. If the defendant says it rejects the advice they're given, they want to fight the case, they might do so. On the other hand, they might say, "Well, I accept that the evidence is very strong. I didn't do it, but I'm going to accept your advice in order to get it over and done with." So you have to then advise them, well, you shouldn't really, if you are going to plead guilty on the basis, of course, it may be that there will be more than one charge. There may be a more serious charge and a less serious charge. One of the decisions that has to be made is whether to offer a plea of guilty to a less serious charge, if in the hope that the prosecution will accept that plea and not proceed on the more serious charge. Somebody might be charged with theft, and in the alternative, handling, that is dishonest handling, receiving property but not actually being the thief. Now you can't be a thief and a handler, so very often the circumstances may, for example, point to the fact that a person was in possession of stolen property so soon after the theft of the goods on the evidence that the evidence points to them strongly points to them being the thief, not merely the handler or the person who received it from the thief. So these would be alternative charges. You're charged with theft and in the alternative handling. And the idea behind this is that the jury will decide whether they think you were the thief or whether you were merely the handler, that is, the receiver of the stolen property. If the prosecution are offered a plea of guilty to handling, they will decide, well, actually, it's a case where the jury might decide that this person was the handler rather than the thief, even though the evidence points to them being the thief, not merely the handler. So that's a decision. You might offer handling as an alternative, and that would either be accepted or rejected. So that's one of the decisions. Now, a person might say, well, I received the property in good faith. I wasn't dishonest. You paid nothing for it and you bought it from a man in a pub. Are you really saying that you didn't know, that you didn't believe or weren't told that it was stolen, or didn't believe that it was that it had been stolen? This is important because there's a distinction between, for the purposes of dishonest handling, property that belongs to another, that if you believe that it had been stolen or dishonestly acquired, a jury could, if they, even though the defendant said, well, I suspected it was stolen, but I didn't believe that it was stolen, that wouldn't be sufficient to convict them of dishonest handling. But usually, I think the jury would say that somebody has a shrewd idea that it was stolen because, when they were offered the property for a knockdown price, it's fairly clear that it must have been stolen. No jury is going to kind of sit there having a philosophical discussion as to whether it was belief or merely suspicion, which is a lower sort of state of mind, a lower degree of apprehension about whether this was stolen or not. So you would advise them, if they told the police that they suspected but they didn't believe, that's simply not going to wash with a jury, and they might be well advised to plead guilty even though they aren't actually guilty in terms of the offence, the precise legalities of the offence. Well, then you have to say, well, you want to be careful here, because in many cases when the case falls to be a decision as to what should be done with them, a court will ask for a pre-sentence report prepared by the probation service. So this is a very difficult situation. As the advocate, I will say to the defendant, you've got to be very careful here. If the court does ask for a pre-sentence report because you haven't been in trouble before, or they may decide that you're on the cusp of being in danger of being sent to prison, and they ought to find out about what the risks are here. Do we need a probation officer to make an assessment of the risk, and whether there ought to be an alternative to prison, a community penalty, unpaid work, that sort of thing, for which you need a pre-sentence report. The one thing you don't want to happen, defendant, is that you go for your interview and you say to the probation officer, well, I've pleaded guilty, but I'm not really guilty, or okay, I'm a little bit guilty, but it's nothing like what the prosecution have alleged. So they have to be advised that they've got to be very careful what they say to the probation officer. If it's no good saying, well, I'm going to plead guilty because I want to get it over and done with, but I'm not really guilty. And I say, well, don't tell the probation officer you're not really guilty, because the probation officer is bound to put that in the report. They don't admit they're guilty. So that will go before the court, and the court will then say, well, look, your client is saying he's not really guilty. He or she is not really guilty. Why have they pleaded guilty if they're not really guilty? I'm going to have to put this back for a trial, because this having been said, we're not going to accept the plea of guilty. Or you say, well, the defendant still doesn't want to have a trial, obviously, because of technical reasons. So we say, well, in that case, he goes back on what he said to the probation officer. So what's the result of this? The defendant has lost all credit with the court from having pleaded guilty at the first opportunity, and is then having to go through the hoops and, well, it was misunderstood, or he's whatever he said to the probation officer, what he says now counts, and it doesn't look good for the defendant.